Good morning. Thank you all for joining us. My name's Nick Oldham. I'm a partner at Mills & Reeves, specialising in construction engineering risks in our insurance disputes team. In the last webinar, my colleagues discussed how one might assume a responsibility and a liability in tort. Today, I'm joined by my colleagues Nathan and Tim, who also specialise in construction risks. And over the next 20 minutes, we're going to look at how else one might take on a liability, which we might share with other parties to a contract, and how the courts, when they're invited to do so, apportion liability between the various wrongdoers. I've got a couple of housekeeping matters to deal with before we really get going. Note that this session is recorded and will be available to a little later on. We can't see you, but more regrettable than that is that you can see us, or certainly you can see me. If you do have questions, please do pose them in the Q&A box. And at the end of the session, I'm said to tell you that we welcome feedback. And so please do complete the feedback survey. Right, Nathan, remind ourselves how a duty and a liability might rise.
Thanks, Nick. So the best starting point for us really is to briefly remind ourselves what a typical project might look like. If you take a look at your screens, you'll see on there, we've got what you'll probably recognize as the typical diagram. I don't propose to go into that in any detail, but do keep that in mind as we walk through the various liabilities. The first, and perhaps one of the most common ways, is directly through contract. As most of you will be familiar with, the first place to look is the contract itself, including any appointments. The duty to exercise reasonable care and skill is something that's usually clearly set out in its terms. The second is tortious liabilities. All we need to know for the purposes of today is that that's the duty to take reasonable skill and care for any responsibility you might have on the project. That's concurrent with and not instead of any contractual liability, and is limited to the extent of that contractual liability. If you want to find out a little bit more about that, I'd certainly suggest taking a look back at our February 2023 edition, where my colleagues discussed exactly that. The third way a liability or duty might arise is through collateral warranty. And what they do, as you'll see on the diagram, is provide a contractual relationship where otherwise there wouldn't be one. So, for example, between your subcontractor and your employer. For more information on that front, I'd suggest checking out our January 2023 edition. And last but by no means least is a mention of the Defective Premises Act. In general terms, that imposes various duties on parties to a project in relation to the construction of dwellings. That is, unless it's that Section 2 applies and your particular project is part of a Secretary of State approved scheme and that you substantially complied with any design or construction requirements. Thanks to the recent developments in the BSA 2022, we now have longer limitation periods for those claims. For example, we've now got a 15-year prospective and 30-year retrospective limitation for certain claims under that Act. So it certainly looks like we'll see more of those coming through in future.
Thank you. So we've seen how one might have a direct liability. So now let's turn to where there is more than one defendant and there is a multitude of claims on one project. I think multitude should be the collective noun of claims, but that's an aside. Nathan, can you take us through that?
Yes, so where you've got this multitude of claims, the first thing to be aware of is that in civil liability, even a 1% liability can, in terms of what you might be on the hook for, equal 100%. What I really mean by that, just delving a little further, is that if one party has some liability and has contributed to all of the losses, whoever the claimant might be, then they can sue the one unlucky defendant for all of those losses. But that begs the question, why might a claimant choose to do that? Well, most commonly, it's that they'll want their victory to be more than a Pyrrhic one. For example, there's little point claiming against a subcontractor who's got no insurance and means to cover the claim when the D&B contractor or their insurer, as the case is more likely to be, is in a position to compensate the claimant for everything should the claim succeed. In practice, what this translates to is us seeing different types of claims. So firstly, we've got your direct claims. And this is the case where even if several parties are liable for the damage in theory, it might not lead to a claim against multiple parties. So a good example here is that you've got an employer that suffered some sort of loss and might simply choose to sue the D&B contractor under the main contract. That would include the losses incurred as a result of any failings of consultants or subcontractors employed by that D&B contractor, which you might also hear us refer to collectively as the supply chain. You'll also see multi-party claims, and these are actions where an employer, as the claimant, chooses to sue all of those responsible directly. It could, for example, meaning they're claiming against the D&B contractor in contract and against all the various members of the supply chain in tort, or if they were provided in contract under any collateral warranties. Where we have something like our direct claim and the D&B contractor settles that claim against it, they'll more than likely seek to pass their usually significant liability to the employer down to those under them in the supply chain. They can do this either in contract, through the contractual relationships that will exist with the supply chain, or through the Civil Liability Contribution Act, provided there's a sufficiently shared liability to the ultimate claimant to pass on which we'll go into more detail later.
Well, it seems horribly unfair that a party that was 1% liable for all of the damage takes the hit. Say the subcontractor who's the 1% might, or more than 1%, less, more likely, might consider the architect was also to blame for not providing a proper detailed design that has led to a confusion. How in practice does that subcontractor go about ensuring that the architect bears its own responsibility? Nathan?
Well, so, I mean, as you say, Nick, where that's the case, the party facing all the liability will inherently need to look at how they mitigate it and bring whoever else they consider to blame into the ring, as it were. There's two real ways that they can do that. Now, if you're still within limitation for whatever the main claim is you might be facing, so 6 years, for example, if it's contract, then you can use Part 20 of the Civil Procedure Rules to pull those other parties into the main claim. Ordinarily, the best time to do that is by 28 days after you've filed any defence, because then you won't need the court's permission. The alternative is to rely on the Civil Liability Contribution Act, which allows a claim to be brought by the defendant for a contribution towards any liability they have, whether that's settled or ordered by the court outside the main claim, provided that they and whoever they want a contribution from share a liability to whoever is claiming against the contribution seeker, and the contribution seeker and the party they're seeking it from have caused the same damage. Using the Act does also have the added benefit that even if the defending party has been required to settle its liability with the ultimate claimant, or has had an award of damages made against it, then they can bring a new action to get that contribution within a period of 2 years from the date of that settlement or judgment. The difficulty kicks in when it comes to working out who should be responsible for what, because all the Act tells us is that it should be based on what's just and equitable in relation to a party's responsibility for the damage in question, which itself is inherently vague.
Excellent. Thank you for those that outline there. We thought we'd have a look at how the courts have decided what is actually just and equitable in real life cases, as it were. And we've got a few examples. The first one we thought we'd look at is McKenzie and Potts. In this case, they discuss the principle of poacher and gamekeeper, and that is where there is the party that commissioned the defect, and being the gamekeeper, sorry, the poacher, obviously, and the party that should have spotted the defect but failed to do so, and they being the gamekeeper. In a fairly straightforward case, the courts have determined that the poacher should bear 80% and the gamekeeper 20%, or 2/3, 1/3 would also be fair and just. In this case, the Court of Appeal held that both parties are called the damage in more equal measure and that the liability should be split 60-40. So whilst there are general principles, each matter is heard on its own facts and the court decides them on those facts. It's merely a starting point. Now, you've heard from Nathan, lovely those voices. We're going to hear from Tim. Tim, could you give us a couple of other examples?
Yeah, thanks, Nick. Good morning, everyone. So the first case we're going to look at is the case of Carillion against RWC and Fee Group from 2011. So this claim related to the development of a train servicing depot near the redevelopment of Wembley Stadium between 2004 and 2006. Carillion had contracted with Fee to be their specialist design and build contractor for the soil nailing works, that is, works to restrain and stabilise the slopes around the excavation for the depot. Robert West Consulting Limited, or RWC, were the consulting engineer and lead consultant in respect to the overall works, responsible for developing a fully detailed scheme and advising on site investigations. The project consisted of significant excavations, leaving exposed clay slopes which became unstable, and attempted remedial works failed to address the large slips that were occurring. Investigations into the slopes revealed deep-seated and shallow instability which had not been adequately accounted for. Proceedings were issued against Fee only initially, however Fee then issued contribution proceedings against RWC, alleging that if they were liable for the losses pursued by Carillion, then so were RWC. Carillion then pursued RWC directly. Carillion's claim was for the cost of the remedial works and the compensation they'd had to pay to Chiltern Railways for the resulting disruption. Carillion and Fee resolved their claim via a consent order for £3.8 million, but it was Carillion's claim against RWC which had continued. As Nick has already touched on, the judgment noted that typically in construction cases, the builder would be apportioned between 66 and 80% of the liability, with the supervisor who failed to pick up on the defects being apportioned the remaining 20 to 33%. The judge, however, concluded that where both contributors have their own responsibilities regarding the same dangers to a mutual client, that split was not appropriate. They concluded that both Fee and RWC had failed to pick up on the potential instability at any time during the design stage, and that both of them had a responsibility to Carillion to pick up on this. RWC bore a significant portion of liability, 40%, because they were more than simply a design checker. They were appointed to design the whole works as the lead consultant and had responsibility to consider whether any further site investigations were needed. Fee, however, bore a greater responsibility in the latter stages, resulting in their 60% apportionment. Again, this case is an example of how the court has a very wide discretion when considering what is just and equitable under the Act, and how every case will turn on the individual facts and merits of the case.
Okay, well, let's jump to a different jurisdiction. Our Australian case considered the apportionment between three liable consultants under the prosaically titled the Wrongs Act.
Indeed, so yeah, whilst it's not a UK case, the Australian case concerning the lacrosse building is a useful illustration again of how the courts can often approach apportionment. So on the 24th of November 2014, an incorrectly extinguished cigarette resulted in a fire breaking out at the lacrosse building in the Docklands region of Melbourne. Fire spread quickly across the building's external cladding, which was an aluminium composite panel, or an ACP, with 100% polyethylene core known as Alucovest. The resulting fire caused over $12 million of damage, and in 2016, the building owners commenced proceedings in the Victorian Civil and Administrative Tribunal, or VCAT, against the builder, alleging that the builder had breached their statutory warranties by using this non-compliant ACP. In response, the builder was claiming an indemnity against their three primary consultants, the building surveyor, the architect, and the fire consultant. At first instance, the builder was held to have breached their contractual warranties through the use of the ACP. However, the builder had not failed to exercise reasonable skill and care in selecting this cladding. It was found that the three key consultants have failed to exercise reasonable skill and care and were deemed concurrent wrongdoers under the meaning of the Wrongs Act 1958. The tribunal held that the three consultants were therefore liable to indemnify the builder to the tune of 97%, 39% for the fire engineer, 33% for the building surveyor, and 25% for the architect. The French backpacker who had inadvertently started the fire was held 3% liable, but luckily for him, on the basis he had not taken part in proceedings, the builder did not seek to recover this 3% from him directly. The consultants appealed, and there were 11 grounds of appeal made. Ultimately, 10 of the grounds were dismissed. The appeal court concluded the tribunal was correct to conclude that the use of the ACP breached the builder's warranties, but the liability for the losses correctly rested with the consultants. The only successful appeal was whether the surveyor's failure to identify and remedy an omission in one of the fire engineer's reports was not causative of any loss. As a result, the building surveyor's liability was reduced to 30%, with the additional 3% added to the fire engineer. The court held the fire engineer was top of the list, but the building surveyor bore a not insignificantly greater responsibility than the architect. Again, this case is useful in highlighting that if a builder has relied upon the specialist advice of a consultant or a subcontractor, they can obtain a significant contribution from them and indeed potentially a complete indemnity.
Excellent. And then one final one. Nathan, I think you're going to tell us about the Blackpool tram case.
Yes, there's just one other case that's quite relevant here. In the Blackpool case, we see that there was an architect who was engaged as a lead designer and who had prepared the initial tender design and specification. A specialist subcontractor then took on full contractual design responsibility for that element in question. In this instance, the court accepted that the architect had a greater overall knowledge and design responsibility of the overall project, as against the specialist subcontractor who'd taken on a much wider contractual obligation and had more detailed knowledge about how the product in question worked. Crucially, that subcontractor had also expressly agreed to satisfy itself that the architect's assumptions were right and had actually done so. With that in mind, the judge therefore said he would have found the architect 1/3 responsible and the specialist subcontractor 2/3.
Excellent. Briefly stepping aside for a moment, we discussed earlier the impact of the Building Safety Act on the DPA limitation period. This does have some practical implications, doesn't it, when bringing defending contribution claims?
It does, yes, Nick. So the crucial point here is to be prepared for previously dead, if you like, or unavailable claims. To do that, what we suggest is you make sure your document retention policies are fit for the longer timeframes over which claims might now arise. Put simply, best of luck seeking or defending a claim for contribution without the necessary evidence. And if you're anything like me, just being told that's the case isn't half as useful as being told why, to which I'd give you a recent example of the BDW case you'll see on the slide. So the key takeaways from this particular application is that originally a claim under section 1 of the DPA was time barred because it was under the old limitation periods. The new limitation periods are of course now include something that's 30 years in retrospective. Because of that, Barrett sought to argue that that extension could lead to a contribution claim being added and to that section 1 claim being added to their pleadings. So they applied to the court for permission to do that. Now, in theory, were that claim to proceed, it would do so under Part 20 as proceedings were ongoing and the main claim wasn't time barred anymore. The court agreed with Barrett's submissions and allowed these additional claims to be added. So clearly what we see here is that claims previously time barred can now be resurrected by the extended periods brought in by the BSA. So, as we've already mentioned, the simple solution here really is preserve your evidence and check your document retention policy.
Excellent. Okay, right. Well, to round up, we're going to ask you to don on your red robes and sit at the bench and determine the apportionment in relation to a case study that I've prepared of various parties to a contract. So we have an employer who's the owner of a distribution centre, a very large shed with a very, very large concrete floor slab. The main contractor settled the employer's claim. He had strict obligations and the earlier failure sort of fell within the obligations, but he decides to sue the specialist subcontractor who designed and installed the concrete slab, and he based them on the calculations of the ground investigation report prepared by the geotechnical engineer. The slab was under-designed, that is, it was too thin. The geotechnical engineer who carried out the GIR said there was some ambiguity as to whether they were instructed to advise on the need for further investigations, boreholes, or to carry out a design report. He did neither, nor did he warn that he had done neither. The structural engineer for the project was appointed to review the designs of others, was sent the calculations on the slab design by the subcontractor, did not comment or warn that there was no design report, and or that the calculations were out, based as they were on insufficient information. So we have your view coming up. Choosing one percentage for each of the parties: subcontractor, geotechnical engineer, and structural engineer. How would you split the liability? Right, okay. So some of you certainly had the tram case in mind here, I think. We have a vast majority of people going for 3%, went for 8%, 67 for 6%, and 29% went for 40% for the subcontractor. The geotechnical engineer, 9% went for 40, 41% went for 25%, and 50% went for 15%. And the structural engineer, the vast majority of people went for 25%. Okay, so had I been the judge, I'd have gone for 6%, 15 and 25. 6%, the subcontractor had taken on the full design responsibility, should have identified that the information from which he based his design was inadequate. It was his job. The geotechnical engineer was essentially did what he was asked to do. He produced the ground investigation report. His failing was really just not to have made clearer the further investigations that could have been carried out, or the report that should have been prepared, a fairly low level given the expertise of the subcontractor, who should have identified it himself. And then the structural engineer, who again, as in Blackpool, he had more detailed knowledge of the entire project, but didn't have the specific expertise that the subcontractor had. And so I put him down at 25%. There's no right answer. This is that's, I guess, the excitement and the risks of litigation. Come to a question. Does anybody have any questions? Right, how did we do today? Please do provide some feedback. Helpfully, or it would be very helpful to us, if you would let us know what topics you would like us to hear about going forward. Thank you. If you'd like us to provide us more detailed answers to any of the questions that we dealt with today or touched on today, please do get in touch with us by email. Our next Breaking Ground webinar is on the 19th of April, and my colleague Neil Howes and Andrew McConnell will be joined by an outside guest speaker, Nirali Kassan, an architect from Hawkins & Associates, and they're going to discuss the role of an architect, its evolution, and the challenges that they face. I hope you will join us on that occasion, and for now, I wish you a good rest of the day. Thank you very much.